The court is in session in the case of State of Juristan versus Armaghan Al-Dawa. The prosecution, you may proceed.
Good afternoon, Your Honor. My name is Sayyid B. Barksha from prosecution, and Mr. Kalimullah, my co-mooter, and Mr. Samin, the legal researcher.
Can you please repeat and a little bit louder?
My name is Sayyid B. Barksha, my co-mooter, Mr. Kalim, and legal researcher, Mr. Samin. Shall I proceed? Your Honor, the first question of the law is that whether this court is competent to trial that case or not. According to the facts, the court is competent to start this trial because, first of all, that the event occurred within the jurisdiction of the Juristan. Because it occurred in the 40 nautical miles of the Juristan. The question of jurisdiction is crucial in determining whether the court of Juristan has the authority to hear and adjudicate this case. So jurisdiction can be divided into territorial jurisdiction and personal jurisdiction and subject matter jurisdiction. Territorial jurisdiction, the incident in question occurred within the exclusive economic zone of Juristan, specifically during the course of the expert team from the port of Zawadar, which is within the Juristan's territory. Therefore, the court of Juristan lies as territorial jurisdiction over the case. And the subject matter jurisdiction, that the incident involves criminal charges related to the alleged killing of Delarozan Kazalbash. The court of Juristan, being a national court, generally has subject matter jurisdiction over crimes committed within its territory or involving its citizens. Shall I proceed to my next question? That whether the killing of Delarozan Kazalbash was murder considering the circumstances of this case or not. The first point is that the intention to kill. Yes, Your Honor, the case indicates that Armaghan Randawa and Ferozabil intended to kill Delarozan Kazalbash in order to consume his flesh and blood for survival. Secondly, consent and coercion. It is important to consider whether Kazalbash's consent was truly voluntary or if it was coerced due to his dire circumstances. While he initially agreed to sacrifice himself, but later he changed his mind when he realized he had personal reason to survive, such as his promise to his girlfriend. This change of heart suggests that his consent may have been influenced by factors beyond his control. Third, that religious belief and legal standards, that the case mentions that Armaghan Randawa and Kazalbash followed the Shanso religion, which apparently permits cannibalism under certain circumstances. However, it is important to establish whether this religious belief is recognized and accepted within the jurisdiction, Juristan's legal framework. So, in Juristan legal framework, the cannibalism is totally illegal, and there is a penalty for that.
Sir, pardon me.
Yes, sir.
You have said that it is totally illegal in the jurisdiction of Juristan. Cannibalism is totally illegal.
Yes.
Can you provide any specific provision of law regarding it?
For example, because they murdered for eating the flesh of that Mr. Kazalbash. So 302 also we can refer to that
All
case.
I am asking, sir, you said that cannibalism is illegal in the jurisdiction of Juristan, state of Juristan.
Yes.
Can you please point out any specific provision?
Whether there is no specific provision, but we can relate this to the section or provisions of the murder, because they first murder, then they will get the flesh and the blood of the Qazalbash. So it is actually.
So you are saying that cannibalism is not lawful. Cannibalism is not unlawful in the state of Juristan.
I'm not saying that it is unlawful. I'm saying that eating the flesh of human by killing that person.
Just put it simple. Whether it is lawful or unlawful.
Specifically,
cannibalism is lawful or unlawful in the state of Juristan.
It's a complex thing that the cannibalism under the circumstances to kill person and get his flesh, it is unlawful, whether maybe in the
simple words, in simple, whether it is lawful or unlawful. Cannibalism is lawful or unlawful?
It is a complex question to the answer there, because it is we can say it is lawful under the under some circumstances, but there were no such circumstances, and we can say in this case it is unlawful.
Unlawful?
Yes.
Do you have any provision?
Related to that, it is not possible to, but
simply it is not unlawful. Cannibalism is not unlawful in Juristan.
Shall I proceed to the next question?
Yeah, you can proceed.
Whether only Armaghan Randawa is liable for the killing of Dil Rozan Qazalbash or not. So that consent and intent, Armaghan Randawa initially proposed the idea of sacrificing Qazalbash to save other. However, it appears that Qazalbash initially agreed to the idea, but later changed his mind due to personal reasons. If he withdraws his consent before his death, that could be a crucial factor in determining the liability of Armaghan Randawa. Secondly, that self-defense or necessity, Mr. Randawa might argue that the killing was done out of necessity to save his life. But in the fact, it was also included that in the we are arguing that if Mr. Randawa used that, he says that I took that self-defense or necessity of to save others. But we say that in the from the prosecution side that initially on 2 days they will survive, and they ate a turtle, so they can be survived by seafood. But their intention was to kill Mr. Qazalbash. So it is the mens rea of that Mr. Qazalbash. Guilty intention was included that to kill Mr. Qazalbash. The Armaghan Randawa was liable for that. If Your Honor, shall I allow my co-mooter to argue?
Hello everybody, and a very good evening to every one of the justices of the court. My colleague has well elaborated the facts and other points of the case. I will assess the honorable court in certain of the points, in the certain of the questions. I will first throw light on the question whether or not cannibalism is lawful under the theory of necessity. Your Honor, we have to dig deep down inside because it is not explicitly stated in any of the provision of the court of Juristan that cannibalism is means allowed under the theory of necessity. First, to say application of cannibalism, yes, we can say theory of necessity can be applied in very harsh circumstances. For example, to say if a person is stranded in the middle of a sea for an extended period, he can, for example, if the Islamic law doesn't allow the eating of tortoise or some other thing, that person may go for eating of tortoise or something wild animals. What is most important, Your Honor, the necessity defense requires a balancing of the harm prevented against the harm caused. So that is a very important point. You need a very huge balancing harm if you are going for an illegal act under the umbrella of law of necessity. Your Honor, proportional response. The necessity defense requires that the harm caused by the action is proportional to the harm prevented. So it again put it weights to my previous point that theory of necessity can be applied in harsh circumstances, but it should not cost the life of a person, a living creature, and in fact, if it is a human being. Alternate option, the crews could explore other alternate options. In the case, the crew members had access to navigational instruments, some trinapes and a turtle. And if we go back to the facts that they actually feeded on a turtle for 3 days. If I come to the conclusion, consent and agreement, the scenario describes a situation where the crew members drew lots and ultimately took action based on consensus. But, Your Honor, it seems very much like a pre-planned and premeditated murder than Lot, because no person on this earth will voluntarily sacrifice his life to save the lives of others. Shall I move to my next point, because the time is marching out?
Any authority is concerned to this point, please? Any authority, any judgment?
Your Honor, we have lots of judgment regarding the case, but the time is marching out, so I will move to my next point. Whether or not the principle of common intention applies to Arosa, Gill and other. Your Honor, principle of common intention. The principle of common attention often referred to as the principle of joint liability. But in that particular
So is it attention or intention?
intention. Sorry, sir. Intention. But in that particular scenario, sir, if you look that Rosa Gill, who said what a delicious and vicious and tasty meat it is, she didn't sound like she is interrogating about the meat, because she was an active member of all those discussions that were going on there in the crew.
Sir, do you know that human flesh is very much tasty, so she might have enjoyed it, and she might have, she asked for it, what kind of flesh is it and of which it is?
No, sir, the point is she was not sounding interrogatively. She said it out of excitement. So there is a difference between excitement and interrogation. If you are an active member of that particular team and you have discussed all...
By mere perusal of the facts, one cannot apprehend whether it was in excitement or in interrogatory way. So how have you came to this conclusion that it was in excitement?
Sir,
there was any explanation?
No, sir, I have just put it to my personal prudence.
So you are putting your own thoughts in the facts?
Prudence, sir. My personal prudence, I have subjected it to my...
If it is about prudence, so you can point out legal point on which you are implicating Ms. Arosa. As of the facts, she didn't know that it was flesh of human.
Yes.
So how are you implicating her?
Sir, the case is, as I first said, she was an active member of the discussion that was going on there in the on the yacht, and when they discussed about that home and who is going to sacrifice his or her life for the rest of us, she was an active member of that team. So I think it is to say that
So that situation, that talk just finished, and after that he was in coma and she was not there. So how are you implicating her in this as a common intention?
Sir, as you said that human flesh tastes very tasty. There was no other human than Mr. Kalabaz or somewhat. He was the only man there, and he was sacrificed. So I will move. And as far as Firoza Bill is concerned, she was a hand in glove with Mr. Arvanda, and she must be. She is equally responsible for this murder. Your Honor, may I move to my prayer? Cannibalism, the act of consuming another person's flesh, is generally considered a serious crime in most legal systems. It is likely that Armagan Randhawa's involvement in cannibalism would be a significant factor in determining his punishment. And it was a murder. So I request the Honorable Court. That in the light of all these aforementioned evidences, arguments, Mr.
Counsel, your time is up. Thank you.
Arvagan Aradana should be convicted of crime. Thank you very much.
The defense counsel, you may proceed.
Hello, Your Excellency, and good afternoon. My name is Munir Ahmed from the side of defense with my co-motor Abdul Qadir and my legal researcher Abdul Said Muslim Shah. I beg to ask that is the court aware of the facts or not? Your Excellency, I am here to assist the court about the first two questions, that is regarding the state jurisdiction and the killing of the Rosen Kazarbash was murder or not. Your Excellencies, may I proceed to the charges or not? The first question regarding that whether the state of Juristan has jurisdiction and competence to adjudicate the case or not. The answer to this question is straightforward, and the answer is no. Because according to the international law on the law of seas, it is clearly mentioned in the international law that a state has only a penal jurisdiction just about 12 to 24 nautical miles away from the baseline or seabed of that state. And that state has not any jurisdiction, any penal jurisdiction away from 12 to 24 nautical miles away from the baseline. As it is mentioned in the facts that the area is extendable to 360 nautical miles. So according to the facts as it is mentioned in international law, a state, if the area of its seabed is extendable, so the state has only economic jurisdiction on that extendable area. It has not any penal jurisdiction over that extendable area.
आर्टिकल 73 और क्लास jurisdictions के हवाले से कोर्ट को असिस्ट करेंगे।
Which?
जैसे कि आपने मेंशन किया कि एक स्टेट की क्रिमिनल जुरिस्डिक्शन 24 नॉटिकल माइल्स तक होती है। इस चीज़ से रिलेटेड इसके बाद आपने इसको भी आपने एक्सप्लेन किया, लेकिन इसके हवाले से आर्टिकल 73 और क्लास को आप उसके हवाले से कोर्ट को असिस्ट करेंगे।
Ease के हवाले से Your Excellency, the area is extendable to 200 nautical miles. सिर्फ 200 nautical miles तक ये एक्सटेंड हो सकता है, इससे ज़्यादा एक्सटेंड किसी भी केस में नहीं हो सकता, जबकि ये केस जो है वो 200 it is mentioned in international law in the history and background of exclusive economic zone, which is mentioned in the memorial page number 7. Apart from that, May I proceed to the question number 2, the issue number 2, which is the whether the killing of the Rozier Kazarbash was murder considering the circumstances of the case or not. The answer to this question is straightforward, and the answer is no, because here the act is committed in a good crime, and in this regard, the section 81 of the Juristan Penal Code comes into execution. And Your Excellencies, I beg your pardon, on page number 10 and first para of the memorial, which is mentioned, the Juristan Penal Code section 81, act likely to cause harm but without criminal intention and to prevent other harm. To prevent other harm, you can cause a slight harm, by which अगर किसी भी जगह पे greater harm cause हो रहा हो तो उसकी वजह से जी
Act likely to cause harm. क्या यहाँ पे act की बात?
सॉरी सर
Act likely to cause harm. क्या यहाँ पर killing या death या murder की बात नहीं है?
No, sir. Apart from that, paragraph number 3rd of the same page, an illustration is mentioned. एक illustration यहाँ पे mention हुआ है कि एक captain of vessel है, उससे अचानक जो रास्ता है वो खो जाता है और वो अपना कंट्रोल शिप के ऊपर खो लेता है. तो वहाँ पर वो एक बड़े बोट को मारने के बजाय वो एक छोटे बोट को कंसिडर करता है और उसमें सिर्फ 2-3 लोग बंदे मारे जाते हैं. अकॉर्डिंग टू द इलस्ट्रेशंस ऑफ सेक्शन 81, इट इज़ मेंशनड कि अगर किलिंग भी यहाँ पर हो जाए ऑन द बेसिस ऑफ ग्रेटर हार्म, कि आप ग्रेटर हार्म को प्रिवेंट कर सके, तो आप किलिंग या मर्डर अकॉर्डिंग टू सेक्शन 81 भी कर सकते हैं.
As per 80, section 81 is concerned, it is about the intention. And intention is in the cases of murder is commendable in self-defense. Because the self-defense where you kill someone, it is not your intention to go and harm someone. And second, the sudden accidents, but not this one. Satisfy the mood. How the cannibalism, which is planned 1 or 2 days before, 3 days before, that we are going to kill someone to eat them, how the intention is working in it. Isn't it a criminal intention?
Ma'am, I beg your attention that the common intention is regarding the question number 2, 3 and 5, and I will leave this answer to my second motor, Abdul Qadir, which will in this regard the answer to the court and assist the court about the common intention.
Any authorities about jurisdiction?
It will be presented by my second co-motor. May I proceed to my second co-motor? Thank you.
Thank you, Your Honor. It's Abdul Qadir. May I proceed from the side of defense? Yes. So, as my co-motor, Mr. Munim Ahmed, proved that the act committed by Mr. Armagan and Dawa was not murder, therefore, the other member of the crew are also not liable for the killing of the Lozin Kazalbash. As whenever any act is done and we want to prove any law or any act or authority regarding to that act, we see whether that act requires, that act fulfills the requirement of that act or not. If that act fulfills all the requirements which are given in that defense, then we can say that such act is done in such defense. Whenever any act is done for a defense and it fulfills all the requirements of that defense, we can say that such act is not an offense. And here we will see that such case fulfills these requirements which are for the act done by Armagan and Dawa or cannibalism. The first requirements for the defense of necessity is whenever any person does an act, he must believe that he is facing a threat, an exact and real threat. The first requirement is this. And when we see in the act case law, it is clearly written that 3 persons were going to die in the ship, and there were no any other way to survive. The first requirement is fulfilled. Second requirement is whenever any person does any act for the defense of necessity, he must not create that threat by himself. When we see to the case law, the ship was not hit by any human being. It was threat. It was not. The threat was not caused by any human being. It was natural. It was by a shark. The second requirement is also fulfilled here. The third requirement for the necessity of defense is that the harm which is caused by the dependent must be less than the threat. Whenever the dependent cause any harm and he is going to be liable for that harm, this must be less than the threat. So whenever one person is being sacrificed for the survival of 3 persons, so the sacrifice of 1 person is less than the death of 3 persons. So the third requirement is also fulfilled. And the fourth requirement for the committing of defense of necessity is that there must not be any realistic alternative left with them. From the start, it is written that when they have no any other way, they ate turtle, they eat turnips. Beside this, they had no any alternative way. They have no any alternative way except of killing someone or eating the flesh of someone. So there are 4 requirements I discussed with you, and these 4 requirements of necessity are fulfilled in this case. So how can we say that the sacrifice of Dilozin Kazalbash is not given for the necessity?
What do you think? Is law of necessity above our laws? Is law of necessity above JPC, the PPC?
Sir, necessity, you are talking only about Allah, but when, in the necessity we violate the constitution. And even the constitution is violated in the time of necessity.
As a student of law, I would not expect anything less than a law. So, do you expect law to be subordinate to law of necessity?
Sir, there is no any superior law than constitution. As I said, the constitution is also violated sometime in the time of necessity when there is no any other way.
Now, sir, you have pointed out towards constitution.
No,
So
I
would like to point out the exact provision which says law of necessity is above the constitution.
No, law of necessity, in the constitution is written that law of necessity is above.
You are saying.
I am not saying that. I am saying whenever there is a emergency or whenever there is a need of any necessity, we can violate many laws in our countries, in the parliaments in other countries.
So in short, you are saying law of necessity is above other laws.
Necessity, I am talking about necessity. Necessity can be in any form.
As you said, law of necessity. Suppose if someone is very poor, the law of necessity gave him the power to do the robbery, killings, if we prevail the law of necessity above our law.
I didn't understand.
You said law of necessity, they are compelled under the circumstances to kill someone.
Yes.
If suppose any person who is very poor is poverty under the circumstances, whether he can go rob someone because he is poor.
No, ma'am, he can't.
The law of necessity, if we prevail the law of necessity.
If you remember you are I said the second requirements for the necessity is that there should be no any alternative way. If you have any alternative way, then you will be liable for that crime. And the ship, there were no any alternative way left with them.
Can you prove law of necessity under any law, any provision of law?
Yes, it is written in article section 81, section 81 of PPC that whenever you cause harm to someone to prevent huge harm, greater harm.
That is self-defense. That is not to kill someone without any purpose. That is to safeguard your life, not to take the life of another person.
As the person who has been killed has given his consent to sacrifice himself for others, and as a later he refused to be sacrificed. But when the lots were drawn, when the lots were drawn, he gave his consent, and suddenly after the lots he went to coma and fell into coma.
Any authority concerned to your point?
There are many cases. There are section, and whenever we are discussing about necessity is an international term. We cannot limitize it to the constitution of any countries. And international law, it is said that you can use necessity in many acts to prevent any huge harms.
So you have told us about section 81. It says good faith. So what was good faith in all this situation?
There was any scientist. Armagan and Dawa by himself was a scientist, and it was the question of welfare of the state of
Irrespective of educational background and anything, I will jump to the constitution.
They were trying.
There is no difference between persons.
They were trying.
They are all equal before law.
They were trying
so do you think that anybody who is scientist has more precious life than the other who is a layman?
Here the quantity, if the quality does not matters, the quantity matters. There were 3 persons surviving on the body of one person who was already in coma. They were lay chance.
It gives other 3 license to kill.
As I said, he by himself gave consent to be sacrificed. If he hadn't gave consent to them, then why would they kill him? And as they say that he refused to be killed, but before falling into coma, he took part in the lots, which means that he has given consent again and again, and then he went to coma. It means he was killed with consent of himself. And there was no any common intention found between. May I have 2 minutes?
Conclude your arguments.
And the other question is whether the other members of the crew has common intention or not. There is no any common intention found between the members of the crew. There is much difference between common intention and similar intention. Whenever 2 persons are going to kill someone and they have the same intention independent of each other, then both the person are liable for their own act, not vicariously to someone. So applying this point on our case, whenever they were trying to sacrifice the life of Dilozen Qazalbash, Feroza Gil suggested that we must only cut one part of his body, so we can get flesh to eat and blood to drink. It will not amount to his death. And the second person is Rosa Gil. When the Dilozen Qazalbash refused to be sacrificed, the Rosa Bill did not take part in any conspiracy about the killing of Dilozen Qazalbash. So there were no any common intention found between common intention of Dilozen Qazalbash, Rosa Bill and Feroza Gil. In the next, yeah. रोज़ा गिल अब तो कह रहे हो कि वो उम्मीद क्यों नहीं करे। मैं तो कह रहा हूँ कि उसको पता ही नहीं था कि वो क्या हो रहा है, क्योंकि जब वो गोश्त खा रही थी तो बार बार पूछ रही थी कि कैसे जायका इसका ये सर हम फैक्ट्स पे बात करें। सर फैक्ट्स में ये लिखा हुआ है कि उसको ये चीज़ पता नहीं थी, उसने ये पूछा है उस चीज़ से। थैंक यू।
Prosecution, you may proceed for rebuttal. And you have only 1 minute.
Shall I proceed, Your Excellency? Has the defense counsel argued that Mr. Armagan Randawa is not liable, and they put two things, that One was that they doesn't. One is that necessity, and second was that alternative. So about necessity, it was crystal clear that there is no such thing like necessity, because and the second thing was alternative. They both are linked with each other, because they had the alternatives at that time, because on this initial day they found a turtle and they ate it. If they will wait it, so they will find the seafood, because they were not in the space, they were on the ocean. So it was, we cannot say that due to necessity they will kill someone. And whether that the Mr. Qazalbash also had that alive, and they will that Feroza Gil cut his jugular vein, so he was died due to that. So he was also that in common intentions. And second, that so the competent court must put Mr. Armaghan Randawa behind the bar, because in the light of my argument, it is crystal clear that Mr. Armaghan Randawa is liable for murder beyond reasonable doubts. Thank you.
The defense counsel, you may proceed for rebuttal. And you have only 1 minute.
प्रोसिक्यूशन अपने आर्गुमेंट्स के दरमियान ये भूल गए थे कि जो मज़हब उनका था, जिस मज़हब में उनको कैनिबलिज़म अलाउ किया गया था, वो इस्लाम नहीं था, बल्कि वो शहनशाह मज़हब था, जो कि वो साबित करना भूल गए। और दूसरी बात कि वो ख़ुद ही हमारे स्टेटमेंट्स बोल रहे थे कि जब वो फ़िश खा रहे, तब वो गोश्त खा रही थी, तो वो बार बार कह रही थी कि ये फ़िश किसने पकड़ा है। हालांकि वो ख़ुद कह रहे थे कि रोज़ा गिल कॉमन इंटेंशन रखती थी, लेकिन अगर वो कॉमन इंटेंशन से कोई काम कर रही थी तो वो कैसे नहीं जानती थी कि ये गोश्त किसका है। तीसरी बात कि वो कैनिबलिज़म के हवाले से कोई भी रिलेवेंट प्रोविज़न प्रोवाइड करना भूल गए थे। उनके पास कोई भी ऐसी प्रोविज़न नहीं थी कि जिससे वो कैनिबलिज़म साबित कर सके या कोई कैनिबलिज़म को वो वाज़े कर सके। और आखिरी बात, उन्होंने कहा था कि ये एक्ट जो है ना वो ये प्री प्लान है। हालांकि ये ना तो प्री प्लान एक्ट था, ये एक ऐसा एक्ट था जो प्लान किसी एक तरह से हुआ था और परफॉर्म किसी दूसरी तरह से हुआ था। और बार बार कह रहे थे कि कोई भी बंदा नहीं है जिसको कोई और बंदा नहीं था जिसको सेक्रीफाइस किया जा सका। तो इस जाहिर सी बात है कि ये ख़ुद कह रहे हैं कि दिलुज़न क़ज़लबाश को मारना चाहिए था और हमने मारा।
Please all rise. The court has adjourned for 5 minutes.